Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law Section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to our Curious Amalgam, the podcast from the American Bar Association Antitrust Law Section. My name is Melissa Maxman, and our topic today is, what's the role of a magistrate judge? Conversation with Judge Lindsey Vaala. Many of you know that the U.S. federal district courts, we have magistrate judges who are appointed to assist the district court judges and generally oversee first appearances of criminal defendants, set bail and other conditions of release, and often handle civil matters through the discovery and pretrial phase. But you may not know that the role of a magistrate judge can be different across districts. In a district like the Eastern District of Virginia, where the trial docket is so fast that it earned the nickname of the Rocket Docket, a magistrate judge can make important decisions and have a great impact on litigation there. How should practitioners best leverage their interactions with a magistrate judge? Today, we have the pleasure to speak with Judge Lindsey Vaala, the first magistrate judge interviewed on our program and a longtime active member of the ABA Antitrust Law Section. She talks about her previous career as an antitrust litigator, her path to the bench, and, to the extent that she can speak, her views on current antitrust issues. Joining me today is my co-host, Anora Wang. Hi, Anora.
Hi, Melissa.
Who's our guest today?
Our guest, the Honorable Judge Lindsey Vaala, has been a magistrate judge for the United States District Court for the Eastern District of Virginia, EDVA, in the Alexandria Division since 2022. Judge Vaala began her private practice in 2009 in Washington, D.C., where she worked as associate and then a counsel for an international law firm and became a successful antitrust litigator in both criminal and civil antitrust matters. Judge Vaala is a 2002 graduate of Davidson College. She received a Master of Arts from NYU in Madrid in 2003 and graduated from the College of William and Mary Law School in 2008. Right after law school, she served as a law clerk to the Honorable Teresa Carroll Buchanan in the Eastern District of Virginia from 2008 to 2009. Judge Vaala has long been an active member of the ABA Antitrust Law Section, where she served as a co-chair of the section's Cartel and Criminal Practice Committee in 2018 through 2022, and is currently on the Judicial Advisory Board of the section.
Great. So without further ado, Judge Vaala, welcome to the program.
Hi, Melissa. Hi, Anora. Thank you so much for having me. I am pleased to be here and tickled to be your first federal magistrate judge on the program.
We're thrilled. And since we knew you before you were a judge and in your position as a section, we're especially proud of you. We're hoping to structure our conversation around several high-level questions about your professional experiences and helpful pointers for practitioners. First, we're going to obtain a bit of education from you, as many of our listeners probably don't have a good idea about what a magistrate judge does in general, and more specifically, what it's like to be a magistrate judge in the Rocket Docket district like the Eastern District of Virginia. First, does each magistrate judge develop or have certain kinds of specialties, such as certain types of criminal or civil litigation?
At least in Alexandria, the division that I'm in, so the Eastern District of Virginia has 3 divisions: Alexandria, where I am, Norfolk, and Richmond. And then actually there's a small courthouse in Newport News that is covered by the Norfolk courthouse. But in Alexandria, there are 4 magistrate judges, and we don't develop specialties during our time on the bench, but we come in with our own unique backgrounds. And I think, frankly, we're chosen in part because of our backgrounds and the need to balance the kind of the experience that we came from. So I had some criminal experience on the antitrust side and a lot of civil experience. Another one of my fellow magistrate judges has a deep civil background. And then the other 2 magistrate judges, as I said, there are 4, both came from criminal backgrounds. One was a longtime assistant public defender, and the other was a longtime federal prosecutor. So once we get on the bench, we become generalists. We handle all types of issues and all types of cases. And I'll talk a little bit about how cases are assigned to us, but we are chosen to try to balance the experience that we come in with.
Sounds like a good plan.
Yeah.
Anora, go ahead.
Yeah. Eastern District of Virginia is a large district. How many district judges and magistrate judges are there?
Ooh, you're putting my memory to the test. I know in Alexandria there are 7 district judges, 4 what we call active, and 3 are senior. The only difference with the senior district judge, is that they may take a lighter caseload. In Alexandria, there are 7 district judges, and then there are 4 magistrate judges. I'm one of 4. In Richmond, there are 2 magistrate judges, and I think at least 6 or 7 district judges. And in Norfolk, there are 3 magistrate judges, and I think about 5 or 6 district judges. Alexandria has the highest number of magistrate judges, and frankly, Alexandria, of all 3 divisions, gets the largest number of civil cases as well. I think in 2023, we had almost 2,000 civil cases filed in Alexandria alone.
Wow. And not to put you on a spot, but do you know comparatively, are there districts out there, perhaps Texas or somewhere, that has like more judges or magistrate judges than
Yes. DC, the District of Columbia, has more. They have 4 magistrate judges, actually, but I think they have something like more than a dozen district judges. And there's only one. They don't have different divisions within DC. It's just the district court for the District of Columbia. I think SDNY has a larger number of magistrate judges and district judges, but we are one of the biggest, in part because our district covers the whole east side of Virginia.
Let's turn to the things that are unique about the Eastern District of Virginia. We've talked about how quickly everything runs, but I want to talk about something really granular. When we were preparing, you talked about being on duty. What does that mean, and what does that mean for you?
Yeah. Yes. So in Alexandria specifically, and if I talk about the EDVA, I'm really talking about Alexandria because that's what I know the best. The processes are a little bit different across the various divisions. In Alexandria, as I said, there are 4 magistrate judges, and we rotate what we call criminal duty. Each magistrate judge is on criminal duty for 1 week a month. I actually just finished criminal duty recently, so I will have 3 weeks or so before I'm on again. And during that week, all the criminal issues come to that magistrate judge. So any new felony arrests, any preliminary hearings, which is where we determine if there's probable cause for the charges that somebody's been charged with if they've been arrested. We do detention hearings if the government is seeking pretrial detention in a felony case. We do all the warrants that week. So I do search warrants, I do complaints, I do criminal arrest warrants. And when I say search warrants, it's both premises warrants, so vehicles, locations, as well as a lot of electronic type warrants. All that stuff comes to the duty magistrate judge that week.
I imagine this is different for you coming from a civil cartel practice. Can you talk a little bit about the adjustment?
Absolutely. So this has been the biggest learning curve, I would say, for me, transitioning from private practice to being a magistrate judge. I did cartel work in private practice, criminal cartel work, but the criminal work that I was doing in private practice is very different than what I'm seeing now. I didn't do initial appearances. I didn't do detention hearings in cartel cases. And so the cases that I see move much more quickly than some of the cartel work I did and have more procedural steps than I was seeing. We were usually negotiating with the Department of Justice. And then if there was a plea, you would go through the plea process, but there wasn't a lot of the kind of the pretrial criminal stuff that I now handle.
So I imagine that's usually a very stressful week when you're on duty.
It's a wild week. It's the 1 week a month where I really don't have very much control over my schedule. I'm reacting to what is coming in, both on the warrant side, but also on the courtroom side. So I have a 2:00 felony docket every day that I'm on duty, and I hear any new arrests at that time, and then any preliminary detention hearings that need to be conducted, I do at 2:00. So I'm on the bench every day, usually at 2:00. And then I also have I didn't mention this before, but the duty magistrate judge also handles all of the misdemeanor and petty offenses that week. And because the Eastern District of Virginia has a lot of federal property, the Pentagon, CIA, a lot of military bases. Anything that happens on those locations comes to the federal magistrate judges that week.
Wow. Let's talk about the Eastern District of Virginia and how it's the fastest docket in the nation. What does that mean in practice for your job? For example, how quickly do cases actually move?
It's a great question. I get a lot of, in Alexandria, every civil case that's filed is assigned a district judge and a magistrate judge from the beginning, and it's a random assignment. And those are the two judges that'll stay with the case the whole time. The district judge sets a scheduling order pretty quickly after the responsive pleading is filed, whether it's an answer or a motion to dismiss, and usually sets the close of discovery in that order to be anywhere from 3 to 5 months later. So you have about a 3 to 5 month window, pretrial window of discovery, and then you go back to the district judge for the final pretrial conference, and they set a trial date that's anywhere from usually 4 to 8 or 10 weeks after the final pretrial conference. You could very easily have a civil case that goes from start to finish in less than a year. On the criminal side, cases move very quickly. More quickly than that, you'll see criminal cases resolved in a matter of months.
That puts a lot of pressure on you guys, or you as a magistrate judge, I would imagine. Can you give us a couple examples?
Yes, absolutely. So one of the, I think, quirkiest things about the Eastern District of Virginia and Alexandria in particular is we have what we call an expedited discovery motions process. Because the discovery timeline is so short or so abbreviated, so quick, we try to get parties in if they want to be heard on discovery disputes very quickly. And so we do our part as well. And the way that works in Alexandria is if you have a discovery motion that you want to be heard by the magistrate judge, and the magistrate judges hear all the discovery disputes, you file it by 5 p.m. on a Friday, you file your motion, and you notice it for a hearing at 10 a.m. the following Friday, so 1 week later. The opposition would be due on Wednesday by 5 p.m., and any reply would be due as soon as possible on Thursday, and then the motion is heard the next day, Friday, by the magistrate judge. It's a very quick, expedited process. We ask parties to keep those motions to 10 pages or less. It's not a firm rule, but we ask them to really focus the issue, so it's something that a magistrate judge can really decide in a week. And then for me personally, it creates a very busy week, particularly if I have Fridays with multiple motions in multiple cases, trying to get my arms around each motion, each opposition, each reply. And then we hold hearings. We very rarely do things on the papers. We hold hearings, and we often rule from the bench. So you can imagine my Thursdays in particular are really busy getting ready for those and seeing if the reply changes anything. Sometimes the parties are able to work it out on their own and they cancel it, or they drastically narrow the scope of the motion. But sometimes, the motion goes forward exactly as it was filed the week before.
Right. I have a follow-up question. I think if you take a poll from the public, ask what their sentiment is about the litigation, they probably would tell you they all feel like it's expensive and taking too long. But does it matter whether cases move faster or in more regular paces in other districts they do? I wonder if there are statistics saying at whether decisions coming out EDVA is appealed more or less, or even flipped more or less, given it's doing things faster. Is it also doing things better?
I certainly don't know the statistics. I will tell you that on discovery issues, I've been on the bench a little over a year, and I have yet to be appealed on a discovery issue, but it's only been a year. I think ruling from the bench really helps because you're not waiting for a written order. I do issue a written order, but it usually just says, for the reasons stated from the bench, the motion is denied or granted in part. My view is that it's a painful process as a recently former litigator to have cases move that quickly, but it also, I think, is to everybody's benefit for the reasons you just articulated. It's less expensive, and it also, I think, focuses parties very quickly on what are the key issues and how do we get the discovery we need on those issues, rather than every piece of paper that was ever created in history of time.
We're going to turn in a minute to your litigator turned judge, but I have a follow-up question that is just curiosity. Do you do this all yourself, or do you have a clerk?
Great question. I have one law clerk who actually came with me from private practice. She's phenomenal. She really handles with me the civil cases. The criminal stuff I handle largely on my own, but the civil cases, she and I work together on those motions. And I have a judicial assistant who really works with me on the criminal side. She sets all my warrant appointments and kind of manages the paperwork and the process that goes along with the duty week in particular.
I know you have an 8-year appointment. Your clerk probably don't have to.
So every magistrate judge does it differently. My law clerk came in with me and is staying with me for the first couple of years to try to help me get set up. It's not just the work that's coming in, but also just setting up the process of what my chambers is going to be like. I'm going to run my chambers for the next 8 years. And because she knows me really well and she's a fantastic litigator herself, she just we're working really well together to put together what our process is going to be. A lot of judges do a term clerk, so that they rotate their, like any other district judge, they rotate their law clerk every 1 or 2 years. I may end up moving to a system like that, but for now I have a more of a long-term arrangement.
Aside from bringing your clerk with you, what do you think helped you in your background as a civil litigator, bringing that experience to being a magistrate judge?
So a couple of things jump out at me. The first is clerking was invaluable. Clerking, being a law clerk to I clerked for a federal magistrate judge. In fact, I clerked for the federal magistrate judge who I replaced. When she retired, I was chosen to replace her. So that was an extra special part of my appointment. But she had been on the bench, I think, 14 years when I clerked for her. She retired after 26 years. And my clerkship experience with her really helped me in private practice. And I knew that as a litigator. What I now know is that it also helped prepare me to step in and be able to do this job. But in terms of my litigation experience and working at a big law firm, it was also invaluable. And antitrust cases in particular are complicated. They're long. There's lots of discovery. There's lots of custodians. There's sometimes lots of parties. And so the ability to really dig in and put my arms around those huge cases has helped me be able to move quickly in cases big and small in my new job.
That's perfect. But still, I've heard it's still going to be something surprising or challenging whenever you come to this new job. Was there something like that for you? Was there anything that's particularly challenging during your transition from your private practice to the bench?
The criminal duty weeks are a learning curve, in part because I didn't have a deep criminal procedure background, but also just the pace at which that week moves is like drinking from the fire hose. So that was a bit of an adjustment. The other thing that was an adjustment, sticking on the criminal side, is the sort of humanity of those cases, that when people come before me, they've been newly arrested. I'm the first person from the judiciary that they see after they've been arrested within the past 24 hours. And just the kind of humanity of seeing them there and the dawning that this is happening. And then also the victims. In some of these cases, they're victims as well. And just trying really hard not to take all of that home. I didn't fully appreciate how hard that would be when I first stepped into this role.
Yeah. But you have been a long-time antitrust litigator before this job. Have you missed litigating antitrust cases yet?
I do. I miss particularly the camaraderie of the antitrust bar. I knew so many people in the antitrust bar on all sides of the aisle, and I operated on both sides of the aisle. And so I miss that sort of community. I also miss litigating generally. Sometimes it can be hard to remember that I'm a decider and not an advocate. And particularly if I feel like there's a case that maybe the advocacy on both sides isn't equal. And so it can be hard to resist the urge to step in and fill in the gaps, which is not my job.
So let's talk about your comrades in the antitrust bar. Do you have any particular tips? Because a lot of us in the antitrust bar do general litigation as well. I know I do. I know Anora does. What would you suggest that practitioners should know or could do better, or help their litigations move forward, or help with settlements? I'm free associating here, but
Yeah, and I'm glad you mentioned settlements because I do a lot of settlement conferences. It is one of my favorite parts of this job. I do them in person, at least with lawyers. I like to have the parties there as well, though sometimes the parties participate by phone. But we do a lot of those in Alexandria, and I think they are a smart way to resolve a case. They're usually, you can actually dictate the outcome. You might be able to do something in a settlement that you couldn't get at summary judgment or at trial. They're often less expensive than going summary judgment or trial. So I always put a plug in all my cases when I first see the parties at a initial pretrial conference. I plug settlement conferences. But to answer your question more broadly, thinking about the Eastern District of Virginia in particular, the local rules are so important. And I do I do admission ceremonies as part of my duty week. Every magistrate judge does in-person admissions to the EDVA on Tuesday mornings at 10. I also love those ceremonies because you really get to meet the folks who are joining the EDVA bar. And I tell each and every one of them, make sure you are a master of the local rules and this is true wherever you practice, but in the Eastern District of Virginia, our rules are quirky. For example, if you receive a discovery request in a case, your objections are due 15 days later, not with your responses, but 15 days after you receive the discovery request. And a lot of people forget that, and it leads to can lead to issues in discovery. Just be a master of the local rules wherever it is you're practicing. If you have an active case in a particular jurisdiction, keep those local rules on your desk. And as silly as it may seem, look at them from time to make sure you haven't forgotten something that's specific to the jurisdiction that you're practicing in. The other thing I would say is to really focus on what matters. And I talked about this a little bit when we were talking about how quickly discovery motions move in the Eastern District of Virginia and Alexandria in particular, but you may not need every document and every fact and every deposition. Think about what you really need to prove your case or to poke holes in the other side's case if you're on the defense side, and focus on that discovery and not all discovery that was ever created.
As somebody who's been practicing a long time and literally looks at the rules verbatim every time, I think I worry that I'm getting old and forget the actual language, and I remember what it stands for, so I can't endorse that enough. Look at the rule, even if you quit. Actually, that leads into when I say look at the rule, even if you think you know it. I do this with my associates, with my junior people. And we've heard that you in particular have taken a lot of actions to encourage younger and less experienced attorneys to give them opportunities to speak up in court. Can you explain your thoughts behind it? We entirely endorse it, and I think you're to be applauded for it.
Thank you. This is something I'm still trying to figure out how to handle more systemically in this new role. But I felt very strongly in private practice that giving younger lawyers the opportunity to stand up, whether it was in court or in a client meeting or in a strategy meeting, giving those folks an opportunity to stand up and say, or sit down, say what they think really mattered and was beneficial to, certainly to the lawyer, but also to the group, the team, to have everybody's opinions considered. And then also I think it's sometimes benefit to the client to have younger lawyers arguing motions, because oftentimes the younger lawyers, the associates, are the ones that really know the facts. So I was focused on that in private practice, and I have found it to be a pleasant challenge to think about how to have an impact in this new role. And I haven't totally figured it out yet, but one thing I do is in the admission ceremonies that I talked about earlier, I encourage younger lawyers who are being moved into admission, and also sponsors of younger lawyers, to let me know if they have a discovery motion, and if a younger lawyer plans to handle or would be available to handle even a piece of the motion, to let me know. Because the local rules in EDVA are that one lawyer per side handles the full motion. But if I know that a younger lawyer is ready, willing, and able to handle a piece of the motion, then I will, in my discretion, relax that rule and allow two lawyers for one side to argue a motion, so that younger lawyer has the opportunity to at least argue one issue if they're not positioned to handle the whole motion. So that's what I've done so far.
That's very commendable. And by younger lawyer, I think you mean in relative terms, right? People who probably have, I don't know, under however many years of practice.
Thank you for that clarification. Absolutely. It's less about age and more about years of practice. And that's not something I can really gauge. So that's why I put it on the folks in my courtroom to let me know. And I know there are a lot of judges around the country in various jurisdictions who have standing orders to this effect. And I may ultimately enter a standing order so that people can look at my standing order and know that's something that's important to me. But I wanted to have a little bit of time in this role before I started putting out standing orders.
So let's change gears a little bit. Seeing as this is the podcast of the antitrust section, let's talk about your experience. You're a veteran in criminal antitrust cases and served as a co-chair on the ABA Antitrust Section's Cartel and Criminal Practice Committee. So to the extent that you can talk about it within the bounds of propriety in your role as a magistrate judge, we're curious to hear your views on some antitrust issues that are current. Let's start with no poach and non-competes. They are now, for the first time, at least in a number of years, facing criminal prosecution. If needed, do you embrace that, or do you feel like you should stay on the civil side, or is this an area where we shouldn't?
When I was in private practice, I was the no poach person. That was my issue that I was following on behalf of my team. And so I spent a lot of time thinking about this, counseling clients about in the no poach space and all the sort of adjacent issues to that. I did a lot of employment I worked with our employment team a lot to kind of counsel clients about this space. I handled some DOJ-led investigations in this space. So it's from a personal interest perspective, it's something that I have continued to just follow the headlines and how some of these broader issues have resolved since I left private practice. In terms of what's coming down the pike about criminalizing this conduct, I think I'll reserve comment just in case something like this comes in front of me. But I will say that I have been paying attention to some of the big cases where there were criminal prosecutions pending and how those resolved. And I think it'll be interesting to see if there's a new frontier to the no-poach issue. I haven't seen directly, I think, a no-poach case. I've seen some non-compete issues in civil cases, but they're usually an ancillary part of the case, and it's not usually an antitrust case. It's something else, and there's a breach of contract, and there's a non-compete component to it. I haven't had the opportunity yet to really tackle those issues from this new role, but it's something that I thought was fascinating when I was in private practice, and I've missed being in the mix on those issues to some extent.
Now let's talk about another role that you have just recently taken up. You are now on the ABA Antitrust Section's Judicial Advisory Board. Since it's new, I don't think a lot of our listeners are familiar with it. So what can you tell us about some of the work that the board does, and what do you do within that board?
Yeah, so it's brand new. This is the first inaugural year. I believe I'm the only magistrate judge on the Judicial Advisory Board. I think my sense is that the section is trying to figure out if it's going to be a body that stays together for several years or if there are reappointments every year. I don't know that we know the landscape for that yet, but so far it's been very exciting, and it seems that the focus is really on encouraging engagement. Once you join the bench, there are some considerations about the ways in which you can participate with bar associations and regarding discussion of issues generally. And I think so far my experience has been that the Judicial Advisory Committee or board is really trying to get us more involved or more engaged with participating in ABA section events, with programs like this, speaking opportunities, trying to figure out a way to bring the bench and the bar even closer together to noodle on some of these issues. And it's not necessarily an easy thing to do, but I think for me, it's very fun. I was delighted to be asked. I was pleasantly surprised to be invited, and I hope that they keep me on because I would like to stay involved in whatever capacity makes sense.
I can see you being the judicial representative to the antitrust section at some point, but that's just me.
Oh, well, that would be amazing. There's been a long line of fantastic jurists that have served in that role.
We're rooting for you. Turning to the end of our program, we usually would want to take this opportunity to learn a little bit more about you on a personal level. Could you tell us something about you that people don't know if they just know you professionally?
A couple of things. One, I am a lifelong Buffalo Bills fan, which means I'm very patient. I'm resilient in the face of disappointment. It's been a lifelong struggle, so to speak. I'm from Rochester, New York, and so my family has always and continues to root for the Bills. Another fun fact about me is that I have had a wide variety of jobs, particularly before I went to college and law school. But the one that my mother always wanted me to put on my resume, in fact, she probably wanted me to put on my resume when I applied to be a federal magistrate judge, is that I worked as a deckhand on a packet boat, a replica packet boat on the Erie Canal. So I grew up outside of Rochester in a small town that was right on the Erie Canal. And there was a replica packet boat that used to be pulled by mules walking down the towpath on either side of the canal. Ours was powered by a motor, but I was the deckhand and I did all the lines and we went up and down the locks. And then I also served as an educator, explaining to folks who rode the boat about the canal, the history of the canal, the way the locks worked. And then I also served as the waitress. So I wore lots of hats in that role, but I absolutely loved it. And it was a fun time. I have not put it on my resume in a very long time, much to my mother's disappointment. But she also wanted me to do the work to become the captain. I think you had to do 500 hours or something. And she wanted me to be a packet boat captain, which unfortunately did not work out. But here we are.
I imagine she's pretty proud of you being a magistrate judge.
She wanted me to mention it in my investiture speech, I think. Tell them about the packet boat. It was named the Sam Patch for a guy who jumped over the Niagara Falls and survived.
Ooh.
Oh, wow.
My goodness. Yeah. So would you recommend to junior lawyers that they take a stint as a packet boat?
My advice to junior lawyers is to just get out there and do things that you can't see yourself doing. So yeah, something like that. Honestly, I didn't see this new role that I'm in now coming. So I think staying open to opportunities is something that I've learned how valuable that is, and something that I would definitely impress upon lawyers of any age, frankly, but more junior lawyers in particular. I also found it really valuable to get out of my office to the extent that people are back in the office, or at least step away from your computer and really engage with other people, whether they be people that you work with, people on the other side from you. The ABA section, the antitrust section, was just impactful for me to get involved with, to learn how to use my voice in sort of unusual settings or different settings, to speak at conferences, to put programs together. Really taught me a lot, not only about antitrust law, but also just about being a better practitioner. So I would encourage, and I do encourage, junior lawyers who I come across to do those things as well, because I think you learn a lot when you step away from your computer and think critically in different ways.
Can you tell our audience a little bit about, you said you didn't see this coming, the opportunity. Can you talk a little bit about how the opportunity did arise and what you went through and your decision?
Absolutely. And it's a great question, because the application and selection process to be a federal magistrate judge is something that really doesn't differ across the districts. We have a lot of differences about how we do things, but the actual way that you become a magistrate judge, for the most part, is fairly similar. It's an application process. You throw your hat in the ring. Throwing my hat in the ring was one of the things I didn't see coming. I was encouraged not only by the judge that I clerked for, who is the one who retired, to apply, but I was also encouraged by some of my colleagues as somebody who really had boots on the ground experience with discovery disputes, which is a lot of what I do in this new role. So you apply. There is a merit selection panel that is appointed by the court, and that panel receives all of the applications in the first instance. They decide who to interview, how they want to conduct that process to whittle down the applications. And then they send a list of finalists. And in Alexandria, I think it was 5, a list of 5 finalists to the district judges, who then conduct interviews and make the final selection and appointment. But that process is pretty standard across the various jurisdictions, is my understanding. I have several friends at magistrate judges in other jurisdictions, and they went through a similar process. A fun fact is that when you become a new federal magistrate judge, you go to baby judge school. And so I've met some other new magistrate judges across the country in my baby judge school sessions.
That's fascinating. Thank you again for joining us today. I think we have had a great conversation, and a lot of listeners might benefit from this conversation, perhaps even taking up your cue. Not so much about just clerking, but maybe there's summer jobs too. So thank you again. Until next time.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.